I come not so much to comment on the specifics of what happened at Haverford, DePaul, or Cal Poly, but to provide a legal framework and a cautionary note. In my work with the ACLU and others, I have defended the speech rights of everyone from the National Rifle Association, which I represented successfully in the Supreme Court just last year, to fundamentalist Christians, to Palestinian students. I've also challenged discrimination on the basis of race, sex, and religion. I care deeply about both values, free speech and equality, and both are at stake here. I have 3 points. First, anti-Semitic speech, while lamentable, is constitutionally protected. Just like racist speech, sexist speech, and homophobic speech is. The Supreme Court protected the rights of the Nazi Party to march in Skokie, the home of Holocaust survivors. Sorry, I just turned my thing off. It protected the rights of the Westboro Baptist Church to hurl homophobic slurs at a military funeral. And it protected the rights of the Ku Klux Klan to burn crosses and engage in racist speech. As Chief Justice Roberts explained in the Westboro Baptist Church case, while such speech obviously causes deep harm, the greater danger is giving government officials the power to censor speech by labeling it anti-Semitic, racist, or sexist. Second, Title VI does not prohibit anti-Semitic speech. It prohibits only the discriminatory denial of equal access to education. An anti-Semitic slogan at a protest or online does not deny equal access to education any more than a sexist or a racist comment at a rally does. Anti-Semitic speech implicates Title VI in only 2 narrow circumstances. First, where it constitutes harassment targeted at an individual because of that individual's Jewish identity. Not because he supports Israel, but because of his Jewish identity specifically. And second, where the speech is not targeted, say at a rally, where it is so severe, pervasive, and objectively offensive that it denies equal access to an education. That's a very high standard. It's almost never been met in the case law. That means most anti-Semitic speech does not implicate Title VI at all. Therefore, a school committed to free speech should be tolerating it, not suppressing it, as this committee would ask. And Title VI governs only colleges, not students. So when a student harasses another student, that student hasn't violated Title VI, and the college hasn't violated Title VI because the student doesn't speak for the college. The college only violates Title VI if it is deliberately indifferent to the act. Deliberately indifferent. Again, a very high standard set forth by the Supreme Court in the Davis case and almost never met. That's basically you ignore what has happened rather than respond. Deliberate indifference is not responding to anti-Semitism in a way that this committee doesn't think is sufficient. And that leads me to my third and final point. The line between protected anti-Semitic speech and prohibited anti-Semitic discrimination is necessarily fact-intensive. It requires a careful assessment of what was said, to whom, and why it was said. As a result, it is not sufficient to make general accusations of anti-Semitism, as members of this committee have repeatedly done in all of the prior hearings and already today, any more than it is sufficient under Title IX to label an encounter between 2 students sexual harassment. You need to look at what happened, hear both sides of the encounter, and make a legal assessment, not a political harangue. And therefore, getting to the bottom of what happened here requires fair hearings where both sides are heard about specific incidents. And this committee room is not the place to do that. This committee has not held a single hearing looking into a specific incident and having the perpetrator and the complainant testify and trying to figure out what has happened. Instead, it is engaged in broad-based charges of anti-Semitism without any factual predicate. With all due respect, these proceedings have had more in common with those of the House Un-American
I'd ask the gentleman to
Activities
conclude.
Committee.
You've gone past the 5 minutes.
Yeah, I'm sorry. If I could just, I have one final comment.
Very quick.
It'll take me a second. Yeah, these proceedings, with all due respect, have more in common with those of the House Un-American Activities Committee. They are not an attempt to find out what happened, but an attempt to chill protected speech.
Thank you for
that
your
was
testimony.
A mistake then, and it's a mistake.
Thank you for your testimony.